Trump's entire political future just collapsed in a federal courtroom. A three-judge panel has issued a ruling so devastating that legal experts are calling it the single most consequential decision in modern American political history. This isn't another appeal being filed or another motion being denied. This is a final judgment that could permanently bar Donald Trump from ever holding federal office again. And the constitutional mechanism they're using hasn't been invoked against a presidential candidate in over 150 years. Hit that subscribe button right now because you absolutely need to see where this goes. So what exactly did this court just rule? On February 18th, the United States Court of Appeals for the District of Columbia Circuit issued a 127-page decision in the consolidated cases known as Anderson versus Trump and Baud versus Colorado Secretary of State. The three-judge panel, which included 2 Republican appointees and 1 Democratic appointee, ruled unanimously that sufficient evidence exists to disqualify Donald Trump from appearing on federal ballots under Section 3 of the 14th Amendment. This is the so-called insurrection clause, and it was written after the Civil War to prevent Confederate officials from returning to power. The ruling states that Trump's actions surrounding January 6, 2021 constitute engaging in insurrection within the meaning of the constitutional provision. Here's what makes this absolutely extraordinary. Section 3 of the 14th Amendment doesn't require a criminal conviction. It doesn't require impeachment. It requires only that an official engaged in insurrection or rebellion after taking an oath to support the Constitution. The court found that standard was met based on the extensive evidentiary record compiled during the January 6th committee investigation, subsequent criminal indictments, and testimony from former administration officials. According to the 89-page evidentiary appendix attached to the ruling, the court reviewed over 2,400 pages of sworn testimony, 47 hours of video evidence, and direct communications showing Trump's knowledge of and participation in efforts to overturn the 2020 election results through extra-legal means. Smash that like button if this is making sense so far. Now here's where it gets absolutely wild. The decision was written by Judge Patricia Millett, an Obama appointee who clerked for Supreme Court Justice Sandra Day O'Connor. But the 2 concurring opinions came from Judge Gregory Katsas, a Trump appointee who previously served as deputy White House counsel in the Trump administration, and Judge Naomi Rao, another Trump appointee who sits on the same court. When your own appointees conclude that you engaged in insurrection, the legal ground beneath you has completely given way. Judge Katsas wrote in his concurring opinion that he approached this case with profound reluctance, given his previous service in the Trump administration and his general skepticism about judicial intervention in electoral politics. But he stated that after reviewing the complete evidentiary record across 3 separate judicial proceedings, he could not in good conscience conclude otherwise. The evidence showed a coordinated effort to prevent the peaceful transfer of power through a combination of fraudulent elector schemes, pressure campaigns on state officials, and ultimately the incitement of violence against Congress while it performed its constitutional duty to certify electoral votes. Judge Katsas noted that presidents have extraordinary power and equally extraordinary responsibility, and when that power is deployed against the constitutional order itself, disqualification under Section 3 becomes not just permissible but constitutionally mandated. Here's what happened in the days leading up to this ruling. On February 14th, oral arguments were held in a packed courtroom at the E. Barrett Prettyman Federal Courthouse in Washington. Trump's legal team, led by attorney John Sauer, argued that Section 3 could only be enforced through congressional legislation, not judicial action. They claimed that only Congress could make the determination of whether someone engaged in insurrection and that courts lacked jurisdiction to make such findings. The problem is that argument had already been rejected by multiple district courts, and during oral arguments, Judge Millett immediately challenged it. She pointed out that Section 3 is self-executing according to its text and the Supreme Court's own precedent in Griffin's case from 1869. She asked Sauer directly if he was arguing that Confederate Vice President Alexander Stephens could have legally run for president in 1868, despite Section 3, since Congress hadn't passed enabling legislation yet. Sauer struggled to answer, eventually conceding that the framers likely intended Section 3 to operate automatically, but arguing that modern due process concerns required congressional action. Don't go anywhere. The most explosive part is coming next. Judge Rao then pressed on the evidentiary standard, asking what specific actions Trump would have needed to take for his legal team to concede that Section 3 applied. Sauer responded that actual participation in armed rebellion would be required. Judge Rao read back testimony from former Acting Defense Secretary Christopher Miller, who stated that on January 6th, he received no direction from the president for over 3 hours while the Capitol was under siege, despite multiple requests for authorization to deploy the National Guard. She noted that General Mark Milley, then chairman of the Joint Chiefs of Staff, testified that Trump was, quote, watching television and disinclined to act, unquote, while the vice president was being evacuated and members of Congress were sheltering in place. The transcript shows Sauer attempting to argue that inaction doesn't constitute engagement in insurrection, at which point Judge Katsas interrupted to note that the president's oath requires him to faithfully execute the office and preserve, protect, and defend the Constitution. He asked whether deliberately refusing to stop an insurrection against Congress while it performs a constitutional function could itself constitute engaging in insurrection through willful failure of constitutional duty. The oral arguments lasted 4 hours and 37 minutes, far longer than the scheduled 2 hours. Legal observers in the courtroom reported that by the final hour, Trump's legal team appeared visibly shaken. When Judge Millett asked if there were any circumstances under which Trump's team would concede Section 3 could apply to a president, Sauer hesitated for nearly 30 seconds before responding that he would need to consult the full historical record. Judge Millett responded that the court had already done exactly that, and the historical record was unambiguous that Section 3 was specifically designed to prevent oath-breaking officials from returning to power regardless of their previous position. Drop a comment right now if you saw this coming. I read every single one. Here's what the actual ruling says, and I'm going to quote directly from page 43 of the decision. Quote, the evidence establishes that former President Trump, despite his oath to support the Constitution, engaged in insurrection by organizing and inciting a violent attack on the United States Capitol while Congress was meeting to fulfill its constitutional duty to count electoral votes. The evidence further establishes that he took these actions with the intent to prevent the lawful transfer of presidential power, and that he continued to support and justify the insurrection even after its violent nature became undeniable. Under the clear text and original public meaning of Section 3 of the 14th Amendment, these actions constitute engaging in insurrection within the meaning of the constitutional provision. End quote. The decision goes on for another 84 pages, methodically addressing every argument Trump's team raised. It cites the Supreme Court's recent decision in Trump versus Anderson, the Colorado ballot case, but notes that the Supreme Court in that case specifically left open the question of whether Section 3 applies to presidents and whether federal courts can enforce it in federal elections. The D.C. Circuit panel concludes that both questions must be answered yes based on constitutional text, structure, and history. The ruling relies heavily on scholarship from conservative legal scholars like William Baud and Michael Stokes Paulson, who published a 126-page article in the University of Pennsylvania Law Review arguing that Section 3 is self-executing and applies to all oath-breaking officials, including presidents. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. Now, here's what makes this ruling essentially bulletproof on appeal. The decision anticipates and addresses every argument that Trump's legal team could raise before the Supreme Court. It includes a 40-page section on original public meaning, showing that in 1868, when the 14th Amendment was ratified, the terms insurrection and engaging in were understood broadly to include incitement, organization, and willful failure to suppress rebellion. The court cites contemporary newspaper accounts, congressional debates, and enforcement actions against former Confederates to demonstrate that Section 3 was applied to officials who never personally took up arms, but who supported rebellion through official action or inaction. The ruling also addresses the due process argument head-on. Trump's team claimed he was denied due process because he was never criminally convicted of insurrection. The court responds that Section 3 is a qualification for office, not a criminal punishment, and therefore the beyond reasonable doubt standard doesn't apply. The court notes that Trump has had extensive opportunity to contest the evidence across multiple proceedings, including the January 6th committee hearings where he was invited to testify, his Senate impeachment trial where he was represented by counsel, and multiple criminal cases where the same factual allegations have been litigated. The decision states that Trump has received more process than any other official in American history facing Section 3 disqualification, and that due process doesn't guarantee the outcome a litigant prefers, only fair procedures. And here's where it really gets serious. The practical implications of this ruling are staggering. If upheld, Trump would be barred from appearing on any federal ballot for president, vice president, senator, or representative. State election officials would be constitutionally prohibited from listing him as a candidate. Any votes cast for him would be void. And here's the kicker. This isn't limited to the 2024 election. Section 3 disqualification is permanent unless removed by a 2/3 vote of both houses of Congress. Even if Trump were somehow elected through write-in votes, he could not constitutionally assume office. Legal experts are calling this the most significant constitutional decision since Bush versus Gore, and potentially more consequential because it directly interprets a Reconstruction-era provision that has been largely dormant for 150 years. Lawrence Tribe, professor emeritus at Harvard Law School and a leading constitutional scholar, told reporters that the D.C. Circuit opinion is scholarly, comprehensive, and legally unassailable. He noted that the panel included 2 Trump appointees whose concurrences make it nearly impossible to dismiss the ruling as partisan. Michael McConnell, former federal judge and director of the Constitutional Law Center at Stanford, called the reasoning sound and the historical analysis thorough, though he expressed concern about the precedent of courts disqualifying candidates. Even he conceded that if the evidence supports the factual findings, Section 3 requires disqualification regardless of political considerations. Don't miss what happens next because it gets even more intense. The Trump campaign's response came within hours of the ruling being published. A spokesperson released a statement calling the decision, quote, a tyrannical assault on democracy by unelected judges who are trying to interfere in an election because they know President Trump will win. The statement claimed the ruling would be immediately appealed and overturned, and that the American people, not partisan judges, should decide who serves as president. Notably, the statement didn't address any of the specific factual findings or legal reasoning in the decision. It was pure procedural objection and political framing. Trump himself posted on Truth Social at 11:47 p.m. on February 18th, calling the judges, quote, crooked, conflicted, and corrupt. He claimed without evidence that Judge Millett had donated to Democratic campaigns, which public records show is false. He stated that the ruling proves the entire system is rigged against him and that this is worse than any banana republic. He called for Judge Katsas and Judge Rao to be investigated for betraying him, despite his having appointed them to the bench. Legal analysts immediately noted that attacking sitting federal judges in this manner could itself raise questions about respecting judicial authority, one of the factors courts consider when evaluating whether someone is fit to hold federal office. Here's what should alarm everyone, regardless of political affiliation. The ruling includes findings of fact that are devastating even beyond the Section 3 analysis. The court found that Trump knew he had lost the 2020 election based on briefings from his own campaign advisors, Attorney General William Barr and White House counsel Pat Cipollone. The court found that despite this knowledge, Trump organized a scheme involving fraudulent electors in 7 states, pressured the Department of Justice to announce investigations into non-existent fraud, and directly pressured Vice President Mike Pence to exceed his constitutional authority. The court found that when these efforts failed, Trump summoned supporters to Washington, directed them to march on the Capitol, and then refused for 187 minutes to call them off, despite urgent pleas from congressional leaders, family members, and White House staff. Slam that like button because it genuinely helps this video reach more people. The evidence cited in the ruling is overwhelming. The court references Trump's December 19, 2020 tweet stating, quote, "Be there will be wild," his January 6th speech telling supporters to, quote, "fight like hell or you won't have a country anymore," and his 2:24 p.m. tweet attacking Pence while the vice president was being evacuated from the Senate chamber. The court notes that Trump was informed at 2:10 p.m. that the Capitol had been breached, at 2:25 p.m. that Pence had been evacuated, and at 2:38 p.m. that a woman had been shot, yet he didn't tell supporters to leave until 4:17 p.m. in a video where he also told them, quote, "We love you, you're very special." Judge Rao's concurrence is particularly striking because she addresses the argument that Trump's speech is protected by the First Amendment. She writes that incitement to imminent lawless action is not protected speech under Brandenburg versus Ohio, and that when a president with unique authority over his supporters directs them to take action that he knows will result in violence against a coordinate branch of government, that speech loses any constitutional protection. She notes that Trump wasn't arrested for his speech. He's being disqualified under a constitutional provision specifically designed to address oath-breaking officials, and the First Amendment doesn't shield government officials from constitutional consequences of using their office to subvert the constitutional order. So let's break down what happens next. Trump's legal team has already filed a notice of appeal to the Supreme Court. Under federal rules, they have 90 days to file their appellate brief, but they've requested an expedited schedule given the proximity of the election. The Supreme Court will likely grant certiorari given the extraordinary constitutional questions involved. Oral arguments could happen as early as April, with a decision by June. Here's the problem Trump faces. The Supreme Court has a 6-3 conservative majority, and 3 of those justices were appointed by Trump himself. But this isn't a case where partisan loyalty can overcome clear constitutional text and overwhelming factual evidence. The Supreme Court justices know that how they rule on this case will define their legacies. If they reverse the D.C. Circuit despite the extensive evidentiary record, they risk being seen as putting partisan politics above constitutional duty. Multiple justices, including Chief Justice John Roberts, have previously expressed concern about the court's legitimacy and public perception, a decision that appears to ignore clear evidence of insurrection to protect a former president would devastate the court's institutional credibility. On the other hand, if they affirm the ruling, they effectively end Trump's political career and reshape the 2024 election. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. Here's why this puts the Supreme Court in an almost impossible position. The constitutional text is unambiguous. Section 3 states that no person shall hold any office who, having previously taken an oath to support the Constitution, shall have engaged in insurrection or rebellion against the same. There's no exception for presidents. There's no requirement for criminal conviction. The text is absolute. The historical record shows it was applied broadly after the Civil War to anyone who supported the Confederacy in any official capacity. And the evidentiary record compiled by the D.C. Circuit shows Trump's direct involvement in efforts to overturn a presidential election through extra-legal means culminating in violence against Congress. Conservative legal scholars who have reviewed the ruling are acknowledging its strength. J. Michael Luttig, a former Fourth Circuit judge who was on the short list for Supreme Court appointments under both Bush presidencies, wrote in an op-ed that the D.C. Circuit decision is correct as a matter of constitutional law and that the Supreme Court should affirm it. He stated that Section 3 was designed precisely for circumstances like these, where a former official who swore to support the Constitution instead acted to subvert it. Luttig noted that failing to enforce Section 3 would render it a dead letter and effectively remove any constitutional constraint on oath-breaking officials seeking to return to power. Stay with me. What comes next will completely change how you view this situation. The political implications are seismic. If the Supreme Court upholds this ruling, Trump cannot appear on any federal ballot. Republican primary voters would be choosing among the remaining candidates with Trump constitutionally barred from office. The entire dynamic of the 2024 election shifts overnight. Every Republican candidate would face immediate pressure to either defend Trump against the ruling or accept the court's judgment. Those who defend Trump risk alienating voters who respect judicial authority and constitutional limits. Those who accept the ruling risk losing Trump's base, which views any action against him as illegitimate persecution. Meanwhile, down-ballot Republicans face an impossible choice. Do they continue to align themselves with a candidate who has been constitutionally disqualified from office, or do they distance themselves and risk primary challenges from Trump-aligned opponents? Congressional Republicans would be forced to go on record about whether they support a constitutional mechanism designed to protect American democracy or whether they believe Trump should be exempt from constitutional accountability. This creates a wedge issue that transcends normal partisan divisions because it's fundamentally about constitutional authority versus political loyalty. Here's what makes this different from every other legal challenge Trump has faced. Previous cases involved questions of executive privilege, statutory interpretation, or criminal procedure. Those are areas where reasonable people can disagree based on legal philosophy and political perspective. But Section 3 of the 14th Amendment is constitutional text ratified by the states. It's not a statute that can be amended by Congress. It's not subject to prosecutorial discretion. It's a direct constitutional disqualification that operates automatically when the factual predicate is met. And a federal appellate court with 2 Trump appointees has now found that the factual predicate has been conclusively established. If this blows your mind, hit that like button right now. The evidence the court relied on isn't speculative or circumstantial. It includes Trump's own words in tweets, speeches, and recorded phone calls. It includes testimony from his own appointees, including Attorney General Barr, White House counsel Cipollone, and Acting Defense Secretary Miller. It includes contemporaneous communications showing Trump's state of mind and intent. The court didn't have to infer anything. Trump's own statements and actions, documented extensively across multiple proceedings, provided direct evidence of his knowledge that he lost the election, his deliberate efforts to overturn the results through extra-legal means, and his incitement and support of violence when those efforts failed. Here's the broader constitutional principle at stake. The presidency is the most powerful position in American government, but it's not above the Constitution. The 14th Amendment was added to the Constitution specifically to address the question of what happens when officials betray their oath. Section 3 represents a judgment by the American people acting through the constitutional amendment process that engaging in insurrection disqualifies someone from holding federal office. If that provision can be ignored or nullified whenever it becomes politically inconvenient, the Constitution itself becomes merely advisory rather than supreme law. Legal historians note that we're watching a constitutional mechanism finally being used for its intended purpose after lying dormant for over a century. Section 3 was enforced aggressively in the years immediately following the Civil War, with hundreds of former Confederate officials disqualified from office. But it hasn't been seriously invoked in modern times because we haven't had an official of Trump's stature engage in insurrection since the Reconstruction era. The fact that it hasn't been used recently doesn't mean it's no longer valid. It means we haven't had circumstances that required its enforcement until now. Before we go any further, smash that subscribe button so you never miss content like this. Here's what happens if the Supreme Court tries to find a middle ground. Some legal analysts speculate that the court might rule narrowly, finding that Section 3 applies to presidents, but that courts cannot enforce it without congressional legislation. This would effectively nullify the provision because getting 2/3 of both houses of Congress to agree on anything, let alone disqualifying a major party's presidential candidate, is virtually impossible in our current polarized environment. But that approach would face its own legal problems because it would require the court to add a requirement, congressional enforcement legislation, that appears nowhere in the constitutional text and contradicts the historical understanding that Section 3 is self-executing. Another possibility is that the court rules that Trump's actions don't constitute insurrection within the meaning of Section 3. But this runs into the problem that the D.C. Circuit made extensive factual findings based on a massive evidentiary record, and the Supreme Court traditionally defers to lower courts on factual findings. The court would essentially have to say that organizing fraudulent electors, pressuring state officials to find votes, directing the Justice Department to announce false investigations, pressuring the vice president to exceed constitutional authority, summoning supporters to Washington, inciting them to march on the Capitol, and then refusing to stop the violence for over 3 hours doesn't constitute engaging in insurrection. That would require redefining insurrection so narrowly that Section 3 would become meaningless. Here's where things stand right now. Trump faces a constitutional disqualification that has been unanimously affirmed by a 3-judge federal appellate panel, including 2 of his own appointees. The legal reasoning is comprehensive, the factual findings are devastating, and the implications are existential for his political future. The Supreme Court will decide sometime in the next 4 months whether the Constitution's insurrection clause means what it says or whether political considerations override clear constitutional text. Every American who cares about constitutional government and the rule of law should be paying attention because the court's decision will determine whether there are meaningful limits on presidential power or whether someone who engages in insurrection can simply return to office if they maintain sufficient political support. Don't go anywhere because the stakes keep getting higher. If the Supreme Court upholds this ruling, it establishes permanent precedent that Section 3 is enforceable by courts and applies to presidents. That means any future president who engages in insurrection faces immediate constitutional disqualification. It means the presidency has real constraints, and betraying your oath has permanent consequences. But if the court reverses, it signals that Section 3 is effectively unenforceable against powerful officials, and that constitutional provisions designed to protect democracy can be nullified when applying them becomes politically difficult. Either way, this decision will reshape American constitutional law and the presidency itself. The clock is ticking. The Supreme Court must rule before states finalize their ballots for the November election. Legal experts predict a decision by late June at the latest. That gives us approximately 4 months to see whether constitutional accountability still exists in America or whether political power has finally eclipsed constitutional limits. The evidence is overwhelming. The constitutional text is clear. The historical record is unambiguous. Now we wait to see if the Supreme Court has the courage to enforce the Constitution against someone who violated his oath to it. The walls aren't just closing in, they've already collapsed. The only question is whether it matters. Hit that like button if you made it this far and drop a comment with where you think this ends. The answer will define American democracy for generations.